Good afternoon, everyone. I'm JC Paul from State Bank of India. Good afternoon to everyone and good
Yes.
morning to those from the US.
Good morning. Very good afternoon.
Good
Miss
afternoon,
Paul.
sir. How are you?
Good to see you. You're from office? Yes,
Yeah,
it appears.
from office. Yeah, from office. Okay, yeah.
Yes.
So
should I start?
Yes, please, go on.
So good afternoon, ladies and gentlemen. On behalf of Indian Institute of Insolvency Professionals of ICAI India and International Insolvency Institute USA, I extend a hearty welcome to our distinguished guests and participants joining virtually across the globe to this international webinar on the theme Cross-Border Insolvency and Global Lessons for India. Commencing the inaugural session of the day, we are delighted to have with us Sri Ravi Mittal, Chairperson IBBI, CA Dr. Debashish Mitra, President ICAI, Mr. Ivan J. Zucker, Black Rome LLP, and III Next Gen Chairperson USA, Dr. Ashok Haldia, Chairman IIIPI, and Sri Rahul Madan, Managing Director IIIPI. At the outset, I request and invite Dr. Ashok Haldia, Chairman IIIPI, for his welcome and opening address. Over to you, sir.
Thank you, Prerna. Very good morning, ladies and gentlemen from US, and very good afternoon to ladies and gentlemen from UK and India. It's indeed a great pleasure for me to welcome all of you on first ever initiatives between the International Insolvency Institute of US and the IIIPI of ICAI in India. It's a first ever initiative between the two organizations, the largest body in the United States and the largest insolvency professional body in India. We have been organizing international conferences and have been in touch with the international bodies throughout the world. But from the US and IIIPI, with the III, it's our first initiatives. And I will especially thank Mr. Ivan J. Zucker, a chairperson of Next Gen III, for being part of these initiatives. And I'm sure these initiatives would go long in being more collaborative and coordinated efforts between the two large economies of the world. We are also indeed a great pleasure and privilege to have with us Mr. Ravi Mittal, the chairman of the Insolvency and Bankruptcy Board of India, the regulator for the insolvency and bankruptcy in India, and also the Mr. Debashish Mitra, the president of the Institute of Chartered Accountants of India, the founder of or the promoter of the IIIPI. Ladies and gentlemen, to those of you who are coming from US, UK and other countries, the IIIPI is the largest insolvency professional agencies in India with more than 3,000 members. And not only in terms of numbers, but in terms of value, they are at present handling more than 75% cases of the corporate debtors in insolvencies. It's a front-end regulator set up under the law. It's a quasi-judicial body. It's also a professional development body, so multiple role within the one institutions, and is playing very pivotal role in supporting in the effective implementation of the IBC 2016 in India. With the rapid increase in the globalization, the cross-border trade and investment, the mutual dependence of the global economies has increased a great deal. It is quite evident between the number of corporates, MNCs from the US having business interest in India, and it's also from the number of corporate entities in India having business interest in US and elsewhere globally. The extent, the intensity of this collaboration between the trade and industry is even extends to small and medium-sized enterprises. That being the case, there is a desperate need for a cross-border framework for resolution of insolvencies and the bankruptcy in an effective manner, fairly, and and transparently. In India, the Insolvency and Bankruptcy Code 2016 does provide a framework for the cross-border insolvencies, but then that has been hardly been taken recourse to. The government, the IBBI has come out with the draft work, which is placed for the comments and the discussion on detailed framework on the insolvencies. This conference would help a great deal in learning from the experience in the United States and also globally, and help in developing the cross-border insolvency framework in India. This is one of the 5 international conferences that we have organized so far. We have been greatly benefited out of the experience globally, and so the global organizations have benefited a great deal. Recently, we did organize an international conference with the help of the World Bank and the IFC, and with the participation of the insolvency professionals, the regulators globally. And I'm sure the deliberations today, the inaugural address by the chairperson of the IBBI. Ladies and gentlemen, let me tell you that the IBC 2016 has been a landmark legislation, economic legislation in India, and has been held widely acclaimed as a model law globally. We have with us the chairperson of the IBBI, and it would indeed be a great pleasure to listen to him and to his address to the global audience, and also the address of the President ICAI, who has been the promoter of the triple IPI. We also have with us the Chief General Manager of the State Bank of India, Ms. Paul, who would be addressing on the issues and challenges in the cross-border in the banking sector. She is from the State Bank of India, which is the largest public sector bank in India. With that, ladies and gentlemen, thank you very much, and indeed a great pleasure to welcome you again.
Thank you, sir, for sharing your thoughts and the opening address. I would now like to invite Mr. Ivan J. Zucker, Counsel Black Rome LLP and III Next Gen Chairperson USA for his opening remarks. Over to you, sir.
Thank you very much, and it's a pleasure to welcome everybody on behalf of the International Insolvency Institute. We're excited about the partnership with the ICAI, and we look forward to a number of collaborations. For those of you that don't know the International Insolvency Institute, it is a non-for-profit limited membership organization dedicated to advancing and promoting insolvency throughout the world. Our institute's membership is some of the most senior and respected insolvency practitioners, judges, academics, and financial advisors in the world, and it has valuable people to implement the laws and with regulators and administrators. And as it relates to this panel, we have our speakers are not only judges that have worked and implemented the model law, but people that have worked on drafting the model law as part of the UNCITRAL Working Group 5. And so we're excited to help with the consideration of India's implementation of the model law by providing a valuable resource from our perspective as well. So I thank you for joining. Thank you.
Thank you, sir, for your kind words and joining hands with IIIPI for this webinar. Now I request CA Dr. Devashish Mitra, President, ICAI, for his special address on the occasion. Over to you, sir.
Thank you very much. Good afternoon to everybody from India, and good morning to all the international audience. The chairman IBBI, Mr. Mittal, to those who are representing the International Insolvency Institute USA, Dr. Ashok Haldia, SBI, CGM, Madam, and everybody else who are part of this program. I welcome all of you on behalf of IIIPI as well as the Institute of Chartered Accountants of India. Let me tell you, today, as Dr. Haldia has said, more than 60% of the insolvency professionals in India are chartered accountants. And the institute as well as triple IPI work closely with IBBI regarding the insolvency law, So we take great pride in it. Over the period of time, the triple IPI has grown, and you see, only recently we have got publications out on the ethics, on peer review. So we have been very active. You see, participant in the development of the law relating to insolvency. Cross-border insolvency being a topic which we think has a great future. Triple IPI is working very hard on this, and it is our great pleasure to have an international audience in this seminar. I wish this conference great success, and needless to mention, we will continue to work with SBI, with International Insolvency Institute US, and most importantly, IBBI, in ensuring that the insolvency laws, you see, are understood by all the stakeholders, and we do everything possible to promote the insolvency laws worldwide. Thank you very much.
Thank you, sir, for sharing your vision. Now I request and invite Sri Ravi Mittal, Chairperson IBBI, for his special address on today's theme. Over to you, sir.
Thank you, Prerna ji. Mr. Zakka, Dr. Mitra, Mr. Haldia, Mr. Madan, other distinguished guests, audience from India, US, and other countries, friends. It's indeed a great day today that we are organizing this international conference, international webinar, and I'm very thankful to Triple IP and the International Solvency Institute of USA for organizing this event, and also thankful for giving me an opportunity to speak at this event. As we are all aware that the Indian economy is now becoming part of the international economy, and as the size of the Indian economy grows, business and trade have adapted an international character. Globally, creators and corporates frequently transact business in more than one country. Foreign banks and creators finance Indian companies, while Indian banks have foreign exposure. Moreover, as part of our government's Make in India program, we want to attract foreign companies to set up manufacturing facilities in our country. Global experience demonstrates that cross-border investment decisions are influenced by the insolvency laws in a particular country. In this backdrop, our government is keen to introduce a globally accepted and well-regulated cross-border insolvency law. The UNICITRAL model law has emerged as the most widely accepted legal framework to deal with cross-border insolvency issues. It ensures the least intrusion into a country's domestic insolvency law. Therefore, it has been considered a preferable model for almost every country, and more than 40 countries have adopted this law. Under IBC, Section 234 and Section 235 provide for central government entering into agreements with foreign countries for enforcing the provisions of the code and issuance of letters of request by the adjudicating authority, that is NCLT, to a court or an authority of such country in relation to assets of corporate debtor or personal guarantor or corporate debtors situated in the foreign country. Our adjudicating authorities have facilitated cross-border insolvency in several cases. Jet Airways is one of those cases which exemplify the need for a regime that deals with situations where a corporate debtor may have creditors and assets dispersed across various jurisdictions. Similarly, we have seen in the Videocon Industries case where the company had requested NCLT to include its overseas assets in the ongoing corporate insolvency resolution process. The NCLT permitted the inclusion of Videocom's foreign business in the corporate insolvency resolution process. However, for such situations, the tribunals are processing on a case-to-case basis, and there is a clear need for a cross-border insolvency framework in our country. As I had stated earlier, our country is considering adapting the model law with certain changes, certain India-specific modifications. We understand that the model law will have great benefits for our country. Enacting a model cross-border insolvency law in India will make us an attractive investment destination for foreign creditors, because the insolvency in India will be predictable for foreign companies. The model law will also be flexible and will take care of India-specific issues. It permits countries to refuse recognition of foreign proceeding or provisions if anything is contrary to domestic public policy. Therefore, priority will be given to domestic proceedings. Thus, protection of domestic creditors will be there. It will also empower insolvency representatives to access foreign jurisdiction, avail recognition, cooperation, and also enable foreign representatives to have the same benefits in our country. The model law will guide cooperation and coordination between courts and insolvency professionals in foreign jurisdictions. The model law is, I think, almost ready and is under consideration of the government. However, we want to learn from international experience on several items. The first is that what happens when insolvency proceedings are running in two countries against a company which have properties in these countries. Now, if the insolvency proceedings in one country is completed and the proceeding in other country is still continuing, what happens to that proceeding? Or if the proceeding that has been completed in the country includes assets of the country where the proceedings are still undergoing. So what happens in such situations? Because insolvency, cross-border insolvency has been done in 30-40 countries. So I'm sure there must be experiences of these kind. Similarly, multinationals usually set up wholly owned or publicly owned subsidiaries in countries that they operate. Since these subsidiaries are distinct legal entities, how are they covered? What is the international experience in these respects? I would be happy to listen to these during the webinar that we have today. I look forward to deliberations in today's webinar, which will help us in better understanding of the cross-border frameworks operating in other countries. I wish the webinar all success. Thank you very much.
Thank you, sir. We are grateful for your kind address and the words of wisdom. Now, I would like to invite Sri Rahul Madan, Managing Director, Triple ICAI, to extend the vote of thanks to all our eminent guests present at the inaugural session. Over to you, sir.
Yes, thank you. And let me extend a very good morning and good afternoon to our eminent guests with us on the virtual dais and off the dais participants joining us from across the globe. Indeed, we had the privilege of listening to many leading thoughts and ideas, and I like to point out just few of these. Distress resolution in highly globalized world require a consistent, fair, transparent framework in order to deal with the cross-border issues. And the global experiences around UNCITRAL model law, especially in the developed markets like US, UK, and many other leading economies, may hold many lessons for India where cross-border framework is on the horizon. And I think this is especially relevant and true when the global economies are facing the renewed risks of economic downturn amidst fast rising inflation, along with the interest rates, as we are getting to know about heavy doses of interest rates being raised across the globe, and not only India, of course. So this becomes extremely important. And once the cross-border framework is notified, there would be significant opportunities for IPs, the professionals, and many other stakeholders. Hence, the need, therefore, is to build capacity and be future ready for the professionals, particularly, and keeping in view that requirement, today's webinar is, in fact, one among many others that will come in near future in this particular direction. With that, I'll express my sincerest regards and heartfelt gratitude to our distinguished guests for their presence, time, and sharing their wisdom with all of us. Shri Ravi Mittalji, Chairperson IBBI, CA Dr. Debashish Mitra, President ICAI, Mr. Ivan Zucker, Council and Next Gen Chairman at III USA, and Dr. Ashok Haldia, Chairman, IIIPI. And I also thank III International Insolvency Institute USA for joining forces with IIIPI in creating this unique platform for the capacity building of our stakeholders. And of course, sirs, many thanks again, and request you to kindly stay with us for some more time as we move towards the technical session, as of course, as per your convenience, and look forward to your continued association. And I'll also take the opportunity and welcome the eminent guest speakers in the ensuing technical session, joining us from USA, UK, and India. And this technical session, as you might know, would include a special address by Ms. J.C. Paul, Chief General Manager, Stressed Asset Group, State Bank of India, which will also be followed by a moderated panel discussion among the dignitaries and experts. And with that, thank you again. Namaskar, and back to you, Prerna, for announcing the technical session.
Thank you, sir. So, ladies and gentlemen, now we move post-inaugural session towards the panel discussion of the day on cross-border insolvency and global lessons for India. Now, I may request and invite Srimati J.C. Paul, Chief General Manager, Sector Stressed Assets Resolution Group, State Bank of India, Corporate Office, Mumbai, for her special address before the panel discussion. Over to you, ma'am.
Thank you, Prerna. Sri Ravi Mittal, Chairperson of Insolvency and Bankruptcy Board of India, representatives of Indian Institute of Insolvency Professionals of ICAI India, representatives of the International Insolvency Institute USA, esteemed panelists, and the participants from India and the USA. A very warm good evening to everyone participating from India, and good morning to the participants from across the globe. At the outset, let me thank the organizers for hosting this seminar on cross-border insolvency framework, which is of great relevance at this juncture when regulators, lenders, and insolvency professionals across the globe are increasingly seized of the imperative need for putting in place an effective legal framework for addressing the issues faced while dealing with resolution of corporates which have assets, liabilities, and operations in more than one jurisdiction. As you all know, Insolvency and Bankruptcy Code IBC of 2016 in India is a relatively new legislation, which was introduced, of course, in 2016. The legal framework for insolvency and bankruptcy in India prior to the enactment of IBC, that was fragmented and not very effective, whether it be the BIFR under the earlier Sikh Industrial Companies Act, or the SARFAESI Act, which came in 2002, or the debt recovery tribunals. The presence of multiple laws, forums, and complexities resulted in delaying resolution of stressed assets, leading to erosion in the value of assets of the borrower, making insolvency regulations rather ineffective. Moreover, the evolution of the economic and financial ecosystem in India and across the globe rendered it necessary to overhaul the debt resolution framework in India in line with the best global practices. When compared to the insolvency laws of the UK, which dates back to the 1980s, or those of the USA and Singapore, which are well established and stabilized, in India, insolvency regime under IBC is still at an evolving stage. Government of India and the IBBI have been very proactive in learning from the experience and bringing in the required modifications and amendments to improve the effectiveness of the code. There has been 6 amendments so far, which has greatly enhanced the effectiveness of the code. Introduction of IBC brought in a paradigm shift in the insolvency process in India. The most critical aspect of which is the shift from debtor in possession to a creditor in control regime. The very fact that promoters could lose control and ownership of their enterprises under IBC has resulted in a huge behavioral change in the corporate debtors. IBC has also encouraged better credit discipline and compliance culture by the borrowers in the country, which has acted as a deterrent to the borrowers, leading to lower fresh delinquencies. IBC has also facilitated in reducing NPAs in the banking system through resolution. Of course, we still have a long way to go under IBC. Providing improved insolvency infrastructural facilities and required manpower by way of more number of benches, administrative staff, etc. Digitalization of the processes, all these will greatly enhance the effectiveness of IBC framework and make it more time and cost effective. With this introductory remarks, I would like to delve upon the various aspects of cross-border insolvency framework from a lender's perspective. Why cross-border insolvency framework is required to be put in place urgently? What are the various challenges faced by lenders and other stakeholders while attempting to resolve insolvency of a corporate having presence by way of operations, assets, or liabilities across borders? How standardized, uniform, and unambiguous legal frameworks across jurisdictions can enhance effectiveness of insolvency resolution? What all would be the desirable features, rather a wish list from a financial creditor? With globalization of businesses, many corporates have grown to the status of multinationals and have established presence, operations, have assets, investments across many jurisdictions around the globe. Liberalization of the Indian economy, which started in the early 90s, resulted in many foreign companies investing directly in India. More often than not, the acquisition of the overseas assets is funded from borrowed capital from the financial system. The fact that these acquired entities also avail credit facilities on their own complicates the matter. When any corporate having presence, assets, or liabilities across borders has to be resolved under the insolvency law, the creditors and other stakeholders are faced with various challenges, such as having no legal framework to formally enforce their rights over the overseas assets, different interpretations of the existing laws, divergent processes, concurrent proceedings in different geographies, information asymmetry, absence of formal framework for collaborating with insolvency professionals, valuers, legal professionals, divergent norms with regard to distribution of recoveries, priority of charge, the list can go on. So several jurisdictions have adopted the model law under UN Commission for International Trade Law to address the challenges in resolution of entities having cross-border operations. The model law allows a jurisdiction to enjoy reciprocity from the other jurisdictions which have adopted the same laws. The lenders with exposure to global corporations based out of India will significantly benefit from the cross-border insolvency regime. Once introduced in India, since the assets and resources outside India would also be available for inclusion in the resolution process and would enhance the overall value which can be derived out of these processes. The regime will equally benefit foreign investors. A robust cross-border insolvency law in India would increase predictability and certainty of investment framework and thereby make India an attractive investment destination for foreign investors and creditors. The proposed regime envisages cooperation and coordination amongst courts and insolvency professionals in India and other jurisdictions and provides for a mechanism leading to uniform approach in resolution and enhanced cooperation. However, ensuring standardization of legal provisions, uniformity in interpretations of law, processes, and ease of enforcing cross-border judgments, making the process simple across jurisdictions will be critical for effectiveness of the cross-border insolvency regime. The current framework, as the IBBI chairperson mentioned, Section 234 and Section 235, there are guidelines, but however, the issues with those sections will be, it all depends on availability of bilateral agreements with other countries. Second thing, it also creates anomaly as IBC does not apply to foreign companies. Hence, while Indian companies having establishment in foreign countries may be proceeded against under the insolvency laws of such countries, foreign companies with outstanding debt or assets in India cannot be proceeded under the provisions of the IBC. So in the absence of bilateral agreements, no tool is available as of now to directly tap into offshore assets of the CD or to seek cooperation from foreign administrators in the case of concurrent insolvency proceedings in India and outside. So to illustrate the position, see a resolution wherein assets parked at an overseas geography was successfully monetized jointly by the resolution professionals at two geographies is that of Jet Airways. The IBBI chairperson also mentioned to this case. Since the information is available on the public domain, I would like to take the liberty of discussing the specific matter. In the year 19, the NCLAT, National Company Law Appellate Tribunal, the appellate authority in India, issued an order consequent to which Jet Airways became the first Indian company to be subjected to cross-border insolvency. NCLAT's ruling set a leading precedent in the evolving insolvency law in India, as it directed the conduct of a joint corporate insolvency resolution process under IBC involving cross-border insolvency. As you all know, Jet Airways was admitted under CIRP in India in June 2019. However, a Dutch court had already initiated insolvency proceedings against the company, and a bankruptcy administrator was appointed in Netherlands to take charge of Jet Airways assets located therein, at the instance of European creditors who were seeking the seizure of an aircraft parked in the Schiphol airport of Amsterdam. So upon this bankruptcy administrator, Netherlands-Dutch bankruptcy administrator appointed by the Dutch court approaching Indian bankruptcy courts, praying for the recognition of the insolvency proceedings in the Netherlands, the appellate authority allowed the bankruptcy administrator under the Dutch law to cooperate with the resolution professional in India in order to finalize a resolution plan that would be in the best interest of the company and all its stakeholders. Further, the bankruptcy court ensured that the insolvency professionals from the two countries mutually agreed upon a cross-border insolvency protocol, which was essentially construed on the basis of the principles provided in the UN model law. Thereby, India was recognized as a center of main interest, and the proceedings being held in Netherlands were taken as the non-main insolvency proceedings. Therefore, the case of Jet Airways presents itself to be an interesting study relevant to the legal position pertaining to cross-border insolvency proceedings in India, as it highlights an earnest attempt by the Indian judiciary to be a front runner in evolving principles and effective mechanisms to deal with cross-border insolvency proceedings. Another case which could be of interest is that of an Indian conglomerate which has profitably operating wholly owned subsidiaries abroad. The parent company, which is under stress, has been admitted under CIRP. However, the lenders are not able to include these assets under the CIRP process or stake a claim to the revenues or assets of these foreign subsidiaries, as facilitating legal provisions are not available as of now. I can also cite the case of another Indian conglomerate, which has substantial investment in oil fields abroad. The investment has been made out of borrowed funds from the Indian lenders. However, again, monetization of these assets or these investments for the benefit of the Indian lenders poses difficulties as of now there aren't enabling legal provisions. So these are some live cases we are still battling with. Hence, enactment of standardized cross-border insolvency regime along with group insolvency regime across various jurisdictions based on the model law under UN Commission for International Trade Law will greatly facilitate speedy and effective resolution. Ensuring cohesion in cross-border insolvency frameworks will be critical for the success of the initiative. Cross-border insolvency without group insolvency provisions may face practical challenges in achieving the desired results. Another important aspect will be to address the issue of concurrent proceedings under various jurisdictions or to facilitate consolidated proceedings at the jurisdiction of center of main interest. Or it could be at a jurisdiction of choice by the majority of creditors, allowing creditors to choose a jurisdiction based on various relevant factors such as efficiency and effectiveness of the legal system, acceptability of the judgments by other jurisdictions involved, ease of enforcement of judgments, etc. may greatly improve the resolution time and recovery. Putting in place a distribution framework which will ensure fair and equitable distribution of recovery proceeds amongst various classes of creditors, domestic as well as foreign, will also be a prerequisite for ensuring success of the framework. Priority of charge and sources of funds deployed for creating the assets should be afforded required weightage while deciding on the waterfall mechanism. Extension of cross-border regime to individuals as well, specifically personal guarantors of corporate debtors, will enable lenders to tap into offshore assets of promoters and guarantors on whose credibility and guarantees loans are extended to the entities promoted by them. This assumes significance in the case of economic offenders who have taken refuge in other countries to escape legal consequences for their willful defaults in their home countries. So the various benefits and implications of implementing cross-border insolvency laws could be: one is that India has acknowledged the need for legislation of cross-border insolvency process in sync with the global best practices and has been working on the framework which is at an advanced stage. Since the model law framework hinges on reciprocity, it is important that countries which contribute majorly to the global business and assets adopt the model law without major divergences in interpretation and applicability of the law. It needs global cooperation and collaboration from the governments and international bodies to ensure adoption of the law by majority of the countries. India, as well as other participating countries, would be able to avail the following benefits by adapting the model law in its legislative framework. So the economic benefits could be, it would result in increased predictability and certainty of investment framework, thereby enhancing confidence of international investors. It should also provide flexibility in the sense that it would respect the differences amongst different national laws on insolvency and provide for deviations to be made from UN model law if required, so as to best suit the domestic conditions and maintain consistency with domestic insolvency law, though endeavor should be to minimize divergences. Then protection of domestic interest in public policy exception. Suitable provisions may be incorporated to protect public policy and public interest. Then precedents to insolvency proceedings. Once proceedings are commenced under the code, the adjudicating authority may be provided discretion to not recognize any subsequent proceedings inconsistent with it. So since the adoption of the UN Commission for International Trade Law, that model law by many of the countries is based on reciprocity, Adoption of the law by major jurisdictions, including India, will greatly facilitate effectiveness of the law. Direct cooperation and coordination between courts, insolvency professionals, legal firms, valuers, creditors across jurisdictions, all this will be a prerequisite for the cross-border insolvency framework to be effective. Ensuring that suitable mechanism for the same is put in place as part of the legislation will facilitate consistency in the system and result in a uniform judicial decisions and rulings and provide faster and effective resolutions and value maximization for all the stakeholders. To conclude, the Government of India and IBBI have recognized the importance and urgency of incorporating cross-border insolvency in line with international best practices as part of the Insolvency and Bankruptcy Code of 2016, so as to further enhance the effectiveness of the code. Adoption of the law by majority of jurisdictions, standardization of provisions to the best possible extent, uniformity in interpretation of the law, and standardization of processes across jurisdictions, all this will greatly enhance acceptability and effectiveness of the law. Thank you.
Thank you, ma'am, for your kind presence and sharing your pearls of wisdom. Now, commencing the panel discussion, I'm privileged to announce the panel today. We have with us Justice Christopher Sonchi, Honorable Judge, U.S. Bankruptcy Court, Delaware, Professor Eric Maverick, University of Nottingham, UK, Mr. Eric Danner, Partner, Co-Resnick, Boston, USA, Mr. Raghupati Mishra, Group CFO, Liberty Steels, Advocate Ashish Makhija, an insolvency professional from India, and Advocate Sajeev Deora, insolvency professional for India. And to moderate the session, we have with us CA Shri Priya Kumar, who is a fellow chartered accountant and an insolvency professional. She is the Central Council member, Chairman Corporate Law and Corporate Governance Committee, Chairman Women Members Empowerment Committee, and Vice Chairman of Committee on IBC at ICAI. She is also Director on Governing Board of IIIPI. She is a Managing Partner of SPR and Company and is a consummated risk and forensic audit professional, besides being a prolific speaker on a variety of subjects, including insolvency and corporate laws. Ma'am, over to you for introducing our panelists and proceeding with the panel discussion. And as we commence this session, I would request the participants to please keep posting their questions and query in the chat box provided on the screen, which will be taken up at the end of the session. So over to you, ma'am.
Thank you very, very much for this very generous introduction. And once again, to Ravi Mittalji, to Dr. Devashish Mitra, and Justice Christopher, and every other eminent dignitary here, and to our own Mr. Ashok Haldia. Once again, here's a very, very hearty welcome to this international webinar on the subject of cross-border insolvency and global lessons for India in this space. This is being organized jointly with the IIIP of ICAI, along with the International Insolvency Institute of the United States of America. Prerna had mentioned that you can start logging in your questions, but I have a small recommendation. Maybe you would want to do it in the last 15 minutes because many of your questions may, in fact, get answered in these sessions, and it will be easier for us to review the unanswered ones. Also take this opportunity to invite the very, very eminent panel that we have here. Justice Christopher Sonchi is a judge and a former chief judge of the United States Bankruptcy Court for the District of Delaware. And he was recently appointed as the International Justice of the Singapore International Commercial Court. A very, very frequent and prolific speaker in the United States and other places abroad on issues relating to corporate reorganization. He's also a lecturer in law at the University of Chicago Law School and has taught restructuring to international judges under the aegis of the World Bank and Insolve International. He's also a member of the International Insolvency Institute and various other bodies, including Insolve International. The next panelist we have is Ms. Irit Mivorak, who is a professor of international commercial law at the University of Nottingham and a founder and co-director of the University of Nottingham Commercial Law Centre. And between 1997 and 2003, she practiced law in Israel and led secure transactions, corporate insolvencies, and restructurings. And since 2006, she's an expert advisor to the UK delegation to UNCITRAL Working Group on Insolvency. And in 2013, Irit was appointed senior counsel to the World Bank and headed the bank's global initiative on the insolvency regime. She is also the co-chair of the International Insolvency Institute's academic committee. She's on the editorial board of the Global Restructuring Review Group, the Spanish Journal of Insolvency, the International Advisory of the Singapore Global Restructuring Initiative, amongst many other credentials of hers. The next panelist we have is Mr. Eric Danner, who's a CPA, a CIRA, a CTP, and he's a partner in the restructuring dispute resolution practice, which is Con Resnick, New York, with over 25 years of experience providing financial consulting and economic analysis to very many entities. He has a very large industry experience that spans several domains, such as consumer goods, distribution, environmental services, financial services, telecom, textiles, transportation, etc. Eric has also acted as the CFO, CRO, and CAO roles in both out-of-court and bankruptcy contexts, with experience across wind-down leadership, litigation management, and creditor claims resolution. Coming to the Indian side, we have with us Mr. Raghupati Mishra, Group CFO, Liberty House Group, which is a UK headquartered company. He's a seasoned chartered accountant and management professional with over 25 years of experience and a proven track record of turning around businesses, setting up new businesses, fundraising, debt restructuring, mergers and acquisitions, statutory compliance, etc. He again has exposure to multiple industries like information technology, telecom, oil, steel and energy, and also the very valuable experience of having launched greenfield operations in varied geographies. Also, I'd like to welcome Advocate Ashish Makhija, who's very well known to this audience here, a fellow chartered accountant, an insolvency professional, cost accountant, and a practicing advocate. He's a managing attorney at the AMC law firm, New Delhi, has advised on very many large cases of corporate insolvency and liquidation. He was also the standing counsel for the official liquidator attached to the High Court of Delhi for over 6 years, authored many bestsellers, is a distinguished faculty in many professional bodies, such as ICAI, ICSI, IICA, and law colleges in the US as well. A rank holder in the CA exams and a top rank holder, in fact, from the LLB from Delhi University, presenting Ashish Makhija ji. And we also have with us the last panelist, which is Advocate Sajeev Deora, who's again a chartered accountant, an insolvency professional and practicing lawyer with over 36 years of experience in the areas of restructuring, turnaround, and liquidation of businesses. He's done representations before various regulatory authorities and tribunals in matters pertaining to corporate and economic legislations. His professional associations include being a director in BTG Global Advisory, a UK-based global network of restructuring and turnaround professionals. He's a member of the International Insolvency Institute of HWWICP, a Hamburg-based global organization that supports insolvency practitioners. And he's also listed on the panel of arbitrators maintained by the ICAI India. So with these, we just tried to keep these introductions very short, and there's so much more that one can talk about our eminent panelists today. And it's over to the discussion itself now. My first question is to Mr. Deora. So after 5 years or almost 6 years of the code, the draft framework on cross-border insolvency in India has been made public, the draft part Z, and it's only a matter of time before we hope it's formally notified. And in this backdrop, I think it's fairly imperative to understand as to why, I mean, of course, the reasons are obvious, but it'd be nice to hear you articulate it on why cross-border reforms were critically needed in India. And more importantly, what's the broad definition of the framework? And since this is the first of the series of discussions we are launching, I thought it's important to actually start from the very beginning, the broad definition and why these reforms were needed. And it's over to Mr. Diora.
Thank you, Shipriya. It's a pleasure to be an opening batsman. And of course, on a very important trajectory that you have picked up in your first ball. However, I draw back to what Mr. Mittal said a while ago, that India is heading to be a multi-trillion-dollar economy. So it will be $5 trillion in the next few years. Also at the same time, he talked about the Atmanirbhar Bharat, where India is trying to produce more within the country. This means that while our trade is going up, foreign direct investment into India is also going up. Indian investments overseas are going up. So India is becoming more and more globally connected. We had a situation when the insolvency law came in, Section 234 and 235 were brought in. Not much progress was made in 234 and 235, and we did see some jurisprudence showing up, which did bring out the fact that there is a need to recognize the cross-border aspects of international businesses or multinational businesses, as JET and Videocon has been cited. The nature of law which comes up in an economy or a society is based on the socio-democratic setup that we have. So we are a socially democratic state, and we will accordingly adopt the principles which help promote these principles on which the state is founded. So while orderly investing is important, the orderly divesting, orderly closures, orderly recoveries, or orderly changes of management are equally important. And this is the perspective from which the cross-border insolvency laws get incorporated. Not every country is adopting the ancestral model law, which is, of course, laying down only principles of how insolvency in cross-border situations should be carried out. However, if we look at how the corporate structures have been moving on, which is what causes a greater need for this kind of a law, we've had wholly owned subsidiaries, India and overseas. You have subsidiaries within India or overseas. You have joint ventures. You have LLPs and association of persons. You have branch offices. There are liaison offices. Now, most important aspect is franchises. There's nothing in the country, but then yes, there is a franchise of an international brand which is selling here. There are licenses which are operating on cross-border basis, which could be technology, which could be software, which could be brand use, or just the name use. So with such kind of perspective, when business is not always physical, or business is not always in the form that you see real assets, particularly I get reminded of the cryptocurrencies, I get reminded of the non-fungible tokens, the transactions in terms of litigations and handing over of litigations in the residual structure of a corporate entity. Now, if you look at these perspectives, you need something which deals with the businesses on a cross-border basis, where investors, buyers, stakeholders within India can act overseas, and from overseas can act within India. Now, such being the perspective that we are more and more globally connected, and we need to take care of these different aspects of business that on which the structure is getting built or getting built in a much greater manner. We have these social networks. We talk about all the web-based businesses. While there's nothing physical, but we still need to factor for insolvencies. So this is the need what has led to India recognizing that if we have to be part of the global economy in a greater way, as Mr. Ravi Mittal mentioned and others did allude to it, we need to provide for orderly mechanisms where changes in management, recoveries are done in an orderly form. Now, what it intends to achieve, I mean, if I would pull a definition from somewhere and I would read, a cross-border law can help creditors and resolution professionals or IPs to recover assets kept overseas. This is what Raviji mentioned, that how to recover assets overseas, and help in dealing with cross-border legal issues in a more efficient manner. Otherwise, we'd be wasting our resources and running around trees only to recover or to locate where the find is. To ease the carrying out of the law will depend on the extent of formal cooperation and coordination among states. So the greater coordinated and cooperative we are with each other, we'll be able to do the business in a more orderly form. And therefore, 234, 235 are giving way to Part Z of Insolvency and Bankruptcy Code. Please back to you, Shipriya.
You're on mute.
Yeah, thanks, Mr. Deora. And I think it was time that we needed this, and the ILC report also correctly, sort of hinted on the four important aspects of access, recognition, cooperation, and coordination, which is what we hope the Part Z, in its finally, regulated or promulgated state, will ensure for us. Now, the next question I have is for Mr. Ashish Makeja. So we just spoke about the draft Part Z. In your opinion, Ashish ji, what are the key features of the draft legislative text of Part Z? And how is it different from the UNCITRAL model law? Is this direct adoption or are there carve-outs? So over to Mr. Makeja.
Okay, thanks, Shripriya. I think I'm extremely delighted to be a part of this discussion on cross-border insolvency. Well, no one has a quarrel that this is the right time. But I'm only looking at from the Indian perspective that we already have 5 years of insolvency and bankruptcy code. How many cases really we have seen which are involving cross-border? We have been quoting maybe a Videocon case or maybe Jet Airways case for that matter. But according to me, Jet Airways case was not actually a cross-border insolvency case. It was only on the periphery. Well, only time will tell how many cases we're going to get for cross-border. But yes, this is definitely a time to evolve that mechanism based on the UNCITRAL law. Now, coming to a question whether India should adopt UNCITRAL law, the model law which has been specified, or with some tweaks which has already been done, suggested in Part Z, that there have been certain tweaks. And Shripriya, you rightly mentioned about the four factors. I call them as ARCC, access, recognition, cooperation, and coordination. I think the entire model law and the cross-border insolvency law is based on four of these features. As a lawyer, if I may, put on certain aspects, I'm only worried about, besides, how the definition of COMI or establishment, those are certain things which will evolve over a period of time, and they have already evolved in US and other places. But I'm only worried from a legal perspective, and I think Judge Christopher is also there, would like to have the benefit of his some of his experiences on the universality versus territoriality concept. Two, I'm only worried about the committee of courts, the cooperation between the courts. I have seen few cases, and I quote Judge Scalia in Hartford Fire Insurance Company versus California case. He mentioned that there are two strands of committee. One is prescriptive committee, and second is committee of courts. So prescriptive committee is legislative committee, where we say that we must recognize, but on the ground whether they are accepted or not. And I'm going to quote two important instances. Number one, in Cambridge case, a gas transport case, the UK's Privy Council, now they recognize the plan of recognition, which was approved by the US bankruptcy court. So this was one of the wonderful examples. We have been quoting certain examples where UK courts have not recognized, and it has raised a cause of concern. But I'm not really worried, because some courts have really recognized the other jurisdiction. The second, of course, is the Lehman Brothers case, where the US court particularly declined to defer to the English courts, because they said it has got wide ramifications, and those provisions could be diametrically opposite to the interest of the US creditors. So I think we have got all kinds of instances out there. But all I'm worried is that how that going to function is extremely important, how we draft our law. Now, coming to a basic question, that what are the differences between the UNCITRAL model law and the Indian law? Well, there are minor tweaks. If my suggestion is taken, I would say that India should adopt the model law, not do too much of tweaking. Whatever has been done is based on the cultural differences, or maybe the differences which are appearing out here in the insolvency law. So insofar as the applicability is concerned, it was suggested that it should be made only applicable to corporate debtors first, which includes the companies and the limited liability partnerships at the first stage. So it should not be made applicable to the personal guarantors or individuals. But since the recommendations came in 2018, we have seen that India has opened itself to the individual insolvency, also only restricted to personal guarantors, to corporate debtors. So I think IBBI has also suggested in his discussion paper that it should also be opened for such kind of personal guarantors. So I also endorse that view. The second is the exclusion. Whether these provisions should apply to all companies in India. Well, we all of us are aware that financial service providers have been excluded as a category, which includes the banks and the insurance companies and the finance companies. I think that suggestion is well taken, because those have got wider ramifications in Indian context, and also probably some public policy concept may also be involved in that. Now, the other aspect which affects the cross-border insolvency law, and India has also recognized this aspect, is that legislative reciprocity, whether the domestic court recognizes and enforces. Now, there are two aspects: enforcement and recognition. Recognition may be fine, but sometimes the problem is in the enforcement. So I think we need to develop certain law. Over a period of time, of course, there will be a lot of judgments and a lot of interpretations will come on the enforcement of the foreign court's judgment. India has also developed on a reciprocity basis. Some countries do not recognize Indian insolvency proceedings, so therefore India says we will also not recognize those countries, which is fine at this stage. But over a period of time, I would suggest more universality than territoriality. So that is very important. Now, one of the aspects which is different in Indian context is model law says, and other interested parties can also start the proceedings, or they can also apply for recognition. That means it recognizes the right of such persons to commence and participate in the domestic insolvency proceedings. Well, in the Indian context, they have considered it to be too broad, and they have restricted rights only to the creditors. The same definitions have been adopted for COMI and establishment as they are in the center of main interest and establishment in the model law. I think that is not much to be discussed there. But the public policy exception, which has been recognized in India with some tweaking, it says that while considering the question of public policy, whether recognition of an insolvency proceeding outside India is opposed to public policy, now our Indian law provides that a notice must be given to this central government, which of course would be the Ministry of Corporate Affairs. So whether it is manifestly against the public policy or not, which is, I believe, is a good sign. The other aspect which may impact the foreign creditors is giving a notice. Whether individual notices should be given to the foreign creditors or not, Indian law says that, look, we are making a public announcement in newspapers, which is also electronically uploaded on the IBBI's website. So therefore, the individual notices to the creditors should be dispensed with. So this is what has been proposed in Indian law. But according to me, I would say that, look, if an Indian company is functioning in a foreign jurisdiction, now how those foreign jurisdiction creditors are going to look at the IBBI's website all the time. So therefore, it is very important that here the coordination should also be there, or maybe a public announcement is made in a foreign jurisdiction newspaper. So this is also one of the essential things. The last point which I would like to mention is relating to the interim relief. Now the interim relief, India does not recognize as interim relief. On the making of the application, no interim relief is granted. It is recognized only once that the proceedings are admitted. So these are some differences from the model law and the Indian context. So I hope, I think over a period of time, things will evolve and we will see more interpretive judgments on these aspects. So over to you, Sylvia.
Thanks, Ashish ji, and we already have some questions trickling on the chat for you by name. So, but before that, this is for Mr. Raghupati Mishra. What do you think would be the perspectives of industry participants or resolution applicants on the need and rationale of the proposed cross-border framework, and what are your current challenges, and would this solve some of these present challenges which are faced in the context of the prevailing CIRP framework that we have now?
Yeah, good evening, everybody, and thank you, Cyprian, for the question. and the generous introduction that you made a few minutes ago. So I am humbled. And thank you for ICAI and its chairman and managing director for inviting me to this seminar. Being a fellow chartered accountant myself, it's like homecoming. Or quoting Mr. Deora, it is betting in the home pitch, like the second down batsman. Right. So thank you. And as you see, the panelists are widely renowned people and wise people. One judge, one professor, two advocates who are practicing in law. Even Sripriya, you are the co-chair on the committee of law. So I will restrict from the industry side. I will restrict myself to what practically we are facing in India, and set the context for what exactly is IBC in India is doing, and then we will link it to the cross-border part of it. And what are the expectations from the industry and the resolution applicant on this, that we discuss after that. See, if you see, to give the perspective about the Indian law and how it is happening in India to the international participants and my fellow panelists here. In India, this Insolvency and Bankruptcy Code was introduced during 2016, was applicable during 2017, actually started operation in 2018. So around 4.5 years kind of we are there. And quite a few resolutions has happened, quite big ticket items has happened. And it is widely regarded as very good legislation in India, and a lot of results we have seen. And the government of India has been very dynamic, unusually so, and quite nimble-footed in addressing a few concerns, quite a few concerns in fact, on the legislation. And they have, within a short period of time, a lot of amendments has happened to this to make it more relevant and binding. So the loopholes has been plugged also. So it's a good progress, and I haven't seen in the last 25 years any other legislations being so dynamically pursued and in the time span that this legislation has done. However, there are quite a few teething things that we face when when it is implemented. As per Indian law, IBC 2016, if a resolution plan is approved by the Committee of Creditors, the COC, it is approved by the National Company Law Tribunal or the Appellate Authority NCLAT or the final Appellate Authority by Supreme Court of India, then it's binding. Or any of wherever this journey stops, it is binding on everybody. And for the records, IBC overrides all the laws in paper. Practically, it doesn't happen. And the most blatant violations are done by the government agencies, in fact. The government departments like income tax, the goods and service tax, or the erstwhile VAT regime, Provident Fund, ESIs, etc. Practically, what the government has not issued any directive to its own arms, that IBC overrides everything else, and if there is a valid resolution plan there, you should abide by it. Till date, this notification, instruction, or anything has not been given to these departments. And I have a 360-degree view of selling also from the side of selling of these assets to acquiring of these assets. In quite a few companies we have done. The last 2 years we have done some 3 companies acquisitions we have done. And this is not any phenomena that was a few months ago. In the last 2 weeks, we have been slapped with 8 notices from Income Tax Department that as far as assessment year 2008-9's outstandings are there. The resolution plan was for 2020. The Provident Fund Department sees it as they cannot be overruled by any other law. So they go on for legislative route, and quite a few cases are there in either NCLT or NCLAT or High Courts or to Supreme Court. So practically electricity charges to water charges to PF to all other dues, if you see, they do not accept any resolution plan, then you and even they slap a notice to your banker attaching your bank account. Then you have to move to High Court to get it nullified, and then you strike it out with them. So this is how it is happening till date. Till now, it is happening everywhere. So that's how it is. So the problem is, if the government is not able to instruct its own arms to abide by NCLT, when these cross-border insolvency processes are there, where there will be follow-up with different sovereign countries with different government departments, and there, if there is no bilateral treaties, and even if bilateral treaties are there, to follow up with them and with the similar kind of departments there, then how to go about it? These are the difficulties that we are facing, that we envisage that will be there. And if you see what will be, we envisage is that there is an issue of conflict of laws across countries. The different countries have different laws, and even if UNICITRAL is there, then also there will be issues of representative, the foreign representative, how their powers are there, how Indian lawmakers will be dealing with them, then different interpretations by different courts. With the same law, as we know, wise people prefer to differ on the same this thing. This is how it is. So how to go about it? At least we believe that the government should at least 20 to 25 countries, at least the most economically forward countries, should have bilateral treaties. If they can skip Burkina Faso or Trinidad and Tobago, if they don't have the time, but at least 20-25 countries where most of the economic activity happens should have bilateral treaties. And the mechanism that my predecessors and panelists has been saying, and ma'am from SBI told very elaborately on that. That's the first from my side. Thank you.
Thanks, Raghupati ji. So, and your key recommendation is that in addition to the draft Z that we're talking about, the government needs to take bilateral treaties as an imperative, so that you can have seamless coordination, like, for example, we have in the tax law space. Yeah, so thank you.
Everywhere. In India, the government companies or government departments, they do not recognize IBC law, and invariably we go to the court of law, which you understand that it takes their own time. So even if you have acquired an asset through IBC route, you are not done. You will be there for next 3, 5, 10 years, whatever it is, you will be legislating. So this thing in India itself, if it is happening, with other countries, if you have bilateral treaties with all these things taken care of there, then from the day one, it will ease up the transactions.
Sure, sure. I do agree. I mean, in terms of capacity building and, kind of knowledge, but my own personal experience, I've found at least the direct and the indirect taxes authorities have sort of started coming up to speed, and it's only a matter of time, perhaps, that others will come to. I'll go for the next question. This is to Judge Christopher Sonchi. What are the key features of the cross-border framework in US and the experience so far, particularly with reference to adoption of the model law, the UNCITRAL model law, and the kind of coordination and cooperation that you've experienced across jurisdictions? And this is over to Judge Sonchi.
Thank you. I'll very much try to address your questions. I want to thank all of you for inviting me the presentations so far have been very educational for me. I said in our prep session, I think I'm going to learn more than I'm going to teach, and that has absolutely been the case, and I think will be the case. This is fascinating to me, and I appreciate the comments all very, very much. So I think that Ashish put it very well when he talked about access, recognition, cooperation, and coordination. Those really are the hallmarks of how the cross-border law has worked in the US. We call it Chapter 15. It's Chapter 15 of our bankruptcy code. The US did make a few minor changes when we adopted the law, some of them simply to fit, as I believe has been done in India, to sort of fit the word usage, to fit the culture, legal culture, and those changes are fairly minor. So we're pretty much in line with the model law. And just real quick, I believe that a functional, efficient restructuring system is very positive to the growth of economies. I see the benefits of the model law and the benefits of a properly functioning restructuring regime actually at the front end. While it deals with divestment, it promotes investment. When lenders know what will happen in connection with a insolvency situation, they are more secure and willing to extend credit, to invest in equity, to lower interest rates, to lower requirements for return on investment, because there's a way forward in case things don't go wrong. And of course, in business, like everything in life, sometimes things don't go well. Sometimes it's the result of management being poor. More often, I think it's the result of disruption, either economic, social, environmental disruption, technological disruption, which has been a big mover in the United States insolvencies over the last 20 years, lead to these situations where you hopefully restructure a company, but even if you don't, you have an orderly liquidation process. And I think that the US, adopting the model law in 2006, has had benefits both to foreign companies who want to do business in the United States, as well as perhaps more minorly getting investment in the United States. But the reality is when foreign companies are doing business in the United States, even if they're located in Europe or South America, they're benefiting the US economy by doing business in the United States. And having the Chapter 15 framework where we can recognize insolvency proceedings that are going on in foreign countries, again, promotes investment in the United States, which is positive to our economy. And I expect you will see the very same benefits in India if you ultimately adopt the model law. So what do we see in the US? I just want to, just real quick, Ashish mentioned territorialism versus universalism. And I think that's key in how the model law has sort of gone down the middle between those two extremes and would be what I would call and what others call modified universalism. The difference is, of course, territorialism is we just ignore what's going on outside our borders. We focus solely on dealing with the assets and the debt in our particular jurisdiction, do not recognize what's going on and in other countries. Now, that has a lot of advantages, right? Because you're worried about taking care of your country's creditors. You're worried about disposing properly of your company's assets. You're worried about making sure that directors and officers in your country are doing the right thing, and if not, that they're properly chastised or held responsible for that. Universalism is this idea that you don't care anything about what's going on in your company, and you're going to trust wholly in what's happening in a foreign country and just whatever they decide, and even if it's in connection with assets in your own country or claims in your own country or creditors in your own country, doesn't matter. I think both of those extremes don't help economies, don't help restructuring regimes. And the model law does, I think, a very nice job of going down the middle. And most of the lifting there is with the exclusion in connection with recognizing proceedings that are manifestly contrary to public policy. I think that's the heavy lifting in Chapter 15 that makes sure that the courts in the US are doing things that are consistent with due process in the United States, which is probably the most important element of that, and also our regime in connection with absolute priority and how secured creditors have preferences over other types of creditors. I say those are the two primary points of contact where we perhaps don't adopt what's going on in foreign proceedings or recognize what's going on in foreign proceedings because they are contrary to public policy, which deals primarily with, as I said, due process of law issues as well as perhaps absolute priority rules. So where have I seen that? I had a very large Chapter 15 dealing with the Irish resolution, the resolution proceedings in Ireland of two of its largest banks that arose from the 2008-2009 financial crisis. There were just some very preliminary issues with recognition, but what continually sort of cropped up were issues with US creditors who had invested in US assets through the auspices or through the coordination of the Irish bank. They were, in their words, sucked into this proceeding in Ireland, even though they were US citizens and the properties were US, but of course the financing had been through Ireland. And we were able to deal with those cases in a sort of combination of recognition, but making sure that since we were dealing with US creditors and US assets, I'd say perhaps a higher level of ensuring that they were being treated fairly, that due process was being taken care of, and that the assets were being appropriately dealt with. So I had trials in connection with a large sports arena in Tampa, a large hotel in Boston, and then some litigation claims as well. And we were able to deal with those rather efficiently with, always recognizing what was going on in Ireland and being respectful there, but making sure we were taking care of the US creditors and US assets and that they weren't being put in an adverse situation. In the end, also, I think reciprocity is very important. We do not require reciprocity for recognition. Some jurisdictions do. I don't think it's really necessarily the legal issue with regard to reciprocity as much as it creates a culture in the court system of mutual respect. So if I'm dealing with a country that's seeking recognition in the US, but doesn't recognize US proceedings, perhaps, I'm human. Perhaps I look at it maybe with a more jaundiced eye, and it may be a little more difficult for me or a little higher burden to get me to recognize those proceedings. I don't know if it's a club, but I mean, we have 40 countries now, some very large countries, some very small countries, different economies, and who have passed a version of the model law. And I think those countries actually, and the creditors, let's say we'll just throw out a country, say England. I think the British creditors and British debtors perhaps get a sort of easier path through our proceedings because they have a version of the model law. Fairly recently, if I remember correctly, but Urit is the expert on that. So those are my main thoughts in connection with how it's worked. I think it's worked very well. Indeed, I think it has worked very well. There are problems, and most of those problems, though, are on the edges. I'd say 85, 90% of Chapter 15s in the US proceed very smoothly with no kind of issues. But of course, the opinions get written in the hard cases. So when you look at the opinions, all you see is problems, and you don't see the fact that these are the exceptions rather than the rule. But we have problems, and the issues in connection with recognizing the Lehman judgments versus not recognize them there's usually almost certainly in those situations, there's something very specific that's troubling in those cases in connection with, again, it's 1506 in our code, but the manifest, contrary to public policy, I think is hugely important that you have that provision and does most of the lifting when there's some sort of problem. And last, I make a plug with regard to cooperation. I think cooperation among the courts and judges is very important. I'm a member of the Judicial Insolvency Network, which is an informal group of international insolvency judges. And we drafted the guidelines and the modalities for cross-border communication among judges. That has proved very valuable. It's not without controversy. You have to make sure it's consistent with your judicial culture and your legal culture. But I think it's been very beneficial, and I have dealt in cross-border cases with speaking directly with notice to the parties that I'm doing it, speaking directly with Canadian judge, speaking directly with a Cayman Islands judge to discuss the case and coordinate how the proceeding goes. And the nice thing about the guidelines and modalities is it provides a very public, identifiable structure to those communications to make sure the parties are comfortable with what's going on and to make sure the judiciary has guardrails to make sure that what their communications aren't somehow being disruptive to the proceedings or to due process. So I've spoken too long. Thank you for giving me the opportunity to address you today. I very much appreciate it. Oh, you're on mute, Ms. Kumar.
Yep. Very engrossing, I guess. So thank you so much, Judge Christopher. And now it's over to Professor Irit. Now, Judge spoke about the experience in the US. Now, to you, a specific question is, how does the cross-border UN Citral model and what's been the success of its adoption in the other leading economies globally, other than the US? So the non-US context of adoption of the model law. Over to you, Professor Irit.
Thank you. So first, quick three preliminary remarks. First, to thank you, Sri Priya, for the kind introductory remarks earlier, and also to the III and the organizations in India for setting up this important session and inviting me to participate in it. Second, to say that I'm really delighted to hear about the fact that India will soon join the countries that have adopted the model law. So far it's 51 states that have adopted the model law in 55 jurisdictions. And perhaps, as I will discuss later, in fact, the reach of the model law is even broader than just the 51 states, because it isn't relying on reciprocity, at least if it is adopted as it is intended. So, and the third remark is to reiterate what other speakers already said before me, and that it is important to ensure that the model law is enacted is also applied in a way that is conducive to fair and efficient cross-border insolvencies. Cross-border insolvencies of different types and with regard to different types and sizes of enterprises and businesses. So now to the rest of the world, and starting with the UK. So the UK adopted the model law a year after the United States. So in 2006, Britain adopted it in regulation, the cross-border insolvency regulation 2006, and Schedule 1 of the regulation mirrors the UNCITRAL model law. So it is almost the same as the model law. It was enacted with very minimum modifications, essentially in order to integrate the model law into the system. So, for example, we needed to identify those special entities like credit institutions, as was mentioned before me, to exclude them from the coverage of the model law. But otherwise, the modifications are very insignificant. And we didn't include a reciprocity requirement either, similar to the United States. So the British model law follows the provisions and the framework of the UNCITRAL model law, as was intended by the designers of the model law. It includes the set of definitions on main, non-main proceedings and the other definitions, the outbound provisions, so providing authority for English office holders to seek assistance abroad. And most importantly, as was noted earlier, most of the provisions in the model law, and as a result also in the British model law, are about the inbound aspects of the regime regarding access of foreign office holders and creditors to the English courts, recognition of foreign proceedings as main or as non-main proceedings based on the presence of the center of main interest, COMI or establishment, and the provision of relief assistance to such proceedings, as well as provisions on cooperation and coordination. Now, I will refer here to a question that was directed to me in the chat, and the question was about criminal law and how we prove foreign law. So just to mention that criminal aspects are quite outside the scope of the model law, and also the issue of applicable law, the governing law, isn't addressed in the model law. So the model law, as explained earlier, is based mainly on access, recognition, relief, and cooperation. So these are the main provisions, the core provisions. It doesn't deal with applicable law issues. However, it is implied and envisioned in the model law that there will be deference, especially to the main proceedings, through the recognition and relief proceedings, and through that you may also defer to the insolvency law of the main form of the main proceedings. So the model law is the main cross-border regime for recognition relief in the United Kingdom, and as I mentioned, also in 50 other states that have enacted the model law. And as it was already enacted in 2006 in the UK, there have been quite significant experience in applying the model law, and we could see that, like as Justice Sonshi mentioned, the model law has been applied quite successfully against the backdrop of the norm of modified universalism. So the idea of supporting and facilitating a global main collective proceedings through recognition and relief, so that businesses can be administered in an orderly manner, and especially to avoid breakup of businesses and the disintegration of businesses that can prevent beneficial reorganizations. And I can refer here to some empirical studies that I have done, also others have done. I've done an empirical study in 2011 where I looked at all the cases that I could gather from jurisdictions that up till then have enacted the model law, so the UK, the US, but other jurisdictions as well. And I could see that indeed the model law is applied quite successfully, in the sense that it is applied with a universalist or modified universalist norm in mind, in the sense that recognition is given quite speedily, and also the relevant relief is needed in the circumstances. And I can also mention a couple of examples from English case law, where you could see that not only that recognition relief has been given, but it has also been applied quite pragmatically, also to deal with, for example, cross-border insolvency of groups. Even though the model law doesn't deal with groups explicitly, the model law has been applied quite pragmatically, so that we can support global collective proceedings also when it is with regard to more than one entity, an enterprise group. So for example, in the case of Videology from 2008, so this was a Chapter 11, a reorganization process that was started in the United States regarding a parent company incorporated in the US, as well as its wholly owned subsidiary that was incorporated in the UK. The English court recognized the proceedings opened in the United States against both the parent and the subsidiary. So the court found that the parent company's COMI was indeed in the United States and recognized those proceedings as main proceedings, but that the court found that the subsidiary's COMI was in the UK. Still, the court concluded that that subsidiary had sufficient connection to the United States and recognized those proceedings as well as non-main proceedings. So that allowed the English court to tailor the relief and, as a result, support a group centralized process in the United States. Another brief example is the decision in Agrocor from 2017. So their proceedings were opened in Croatia regarding the Agrocor conglomerate, so a parent company and some 50 affiliates subject to a single process, a sort of procedural consolidation process in Croatia. Recognition was sought in the United Kingdom concerning the parent company, and this was granted by the English court, notwithstanding objections of creditors who argued, among other things, that the model law doesn't allow a recognition of group proceedings. The English court rejected this argument because the model law does allow recognition and granting relief to individual companies that may be part of a group. And this is perhaps a moment to also mention that there is another newer model law, ancestral model law that Ancestral introduced in 2019. That is the model law on enterprise groups insolvency, which indeed more comprehensively and explicitly deals with the cross-border insolvency of groups. And that perhaps is a sort of a quick answer without elaboration to what Mr. Makija mentioned earlier about the problems with Lehman Brothers. So you referred to some issues of handling these kind of global groups, and the hope is that the implementation of this newer model on enterprise groups can deal with these matters better. But just as a final word to mention that, as Judge Sonshi also noted, there are some setbacks, some deviations from the idea of universalism or modified universalism in the spirit of the model law, or perhaps simply circumstances where courts, including the English courts, highlighted gaps or uncertainties in the model law system. And perhaps most notably, that was the case in the decision of the English Supreme Court in the case of Rubin versus Eurofinance, but I understand that that will be the core of the next question, so I will stop here.
Thank you very much, Irit. And over to the next question. Would like Judge Sonshi to first speak about this, and then I would also direct this to Irit again. The Article 21 of the model law allows for granting of certain discretionary release upon the recognition of a foreign proceeding as main or non-main. But we've had recent interpretations of the model law, which has caused a bit of uncertainty regarding its application to the enforcement of judgments. Perhaps most impactfully highlighted in the case of Rubin versus Eurofinance SA. Now, would not leaving this issue to interpretation result in a lack of clarity in the law itself and inconsistent interpretations by different forums? And what's your take on this, Judge Sonshi?
Okay, so this is an important situation, and I'm going to read from my notes a little more than I generally would, because I want to make sure I get it right. So the UK Supreme Court, in my understanding, and Eric will of course be probably more better at this than I am. But anyway, the UK Supreme Court decision in Rubin deals with recognition enforcement of a default judgment. I think that's very important. It was issued by former Judge Gerber in New York in an avoidance action. So it's a regular old lawsuit to recover a fraudulent conveyance between plaintiff A and defendant B, and it's a default judgment that plaintiff A gets against defendant B. Doesn't deal with recognition and enforcement of a plan, and that's important. Rubin concluded that the principles of private international law applied to the avoidance judgment rather than the model law, and that under private international law, judgment cannot be forced absent personal jurisdiction over the defendants. Now, the defendants here were not US nationals, they weren't US citizens or persons, they were foreign persons over whom there was an argument there was no personal jurisdiction. So I think that the outcome in that case might be quite different. if it had been a plan, if there had been participation by the creditor, etc. Only if the foreign court, in this case the US, is approving the plan that somehow modifies contracts governed by English law. Obviously that could be a problem because English courts continue to apply the Gibbs rule. But I think Rubin, to a certain extent, gets overblown because it really doesn't deal with recognition of a foreign plan. It's just basic stuff that's been around for a long time, which is recognition of a judgment against a non-US debtor, a non-US defendant in a US court where the non-US defendant doesn't participate and it's a default judgment. I don't view it as a particularly big deal if you, I think, properly distinguish it. So that's my take on Rubin.
Iris,
Garrett's smiling, so she's going to tell me I'm wrong.
Yeah, I quite disagree. No, you have been generous to us, and that is nice. But so I think that the Rubin decision is very significant. First of all, because even if I disagree with it, and we can see that the international community represented and UNCITRAL disagreed with the decision, but the decision was important because it did highlight an issue, an uncertainty in the model law. Just to reiterate the fact, so in Rubin, the English court did recognize the proceedings opened in New York as foreign proceedings, but ultimately refused to enforce any insolvency-related judgments and avoidance judgment concluded by the New York court. And that was because the English Supreme Court concluded that the model law is enacted in the UK, but it is enacted, as I said, with minimum modifications. So the UNCITRAL model law doesn't address the issue of enforcement of insolvency-related judgment. And it didn't constrain it to very specific circumstances. It said it doesn't deal with enforcement of insolvency-related judgments. And the court, and it's a long decision, and the court systematically looked at the various provisions of the model on cross-border insolvency, including the assistance and cooperation, and of course the relief provisions, and in particular, but not only, Article 21G, which says that the receiving court may grant any appropriate relief in the circumstances, but the court concluded that none of these provisions addressed the enforcement of insolvency-related judgments, and therefore, as Judge Sonshi explained, it applied the UK domestic general private international law, which required presence of submission or presence of the defendant in the jurisdiction, and that wasn't the case. And so enforcement was refused. And it is also important to note, so looking beyond the UK and the US, it is important to know that English courts were not the only ones interpreting the model law provisions narrowly regarding enforcement, and not only in the circumstances of Rubin, so in the Republic of Korea, in Japan, and also in the context of discharge and plans. So, and especially regarding Article 21, the discretionary relief, which is potentially broad and could have assisted here because it is quite open-ended, but it has been applied narrowly in various circumstances, and therefore it led UNCITRAL, Working Group 5, which deals with insolvency reforms globally, to negotiate, deliberate further, and eventually draft and introduce another instrument, a new model law. In 2008, it was published, that both clarifies the scope of Article 21, discretionary relief, in the model law, and also complement it regarding the definitions, the process, the conditions for recognition and enforcement of insolvency-related judgments. So it addressed the issue of enforcement of insolvency-related judgments explicitly and directly. So Article X, so that's an odd numbering, but Article X at the end of the new 2018 model on insolvency judgments clarifies that Article 21 of the original model law is broad enough to include insolvency-related judgments enforcement. Namely, it says that the decision in Rubin is wrong, or is not what was intended or is not compatible with the way Article 21 is understood now by the international community. And then the other provisions in the model on judgments provide the relevant definitions, as I said, uniform provisions regarding the procedure for seeking recognition and enforcement of judgments, the requirement to enforce, and the grounds for refusing enforcement. So to summarize, this decision in Rubin did teach us that when there are gaps or uncertainties in an international instrument, such as the model law, it may be applied in different ways in different countries, and that can undermine the cross-border insolvency framework. So in my view, it is advisable and preferable that countries do adopt the existing model law, but also this additional model law, the model on judgments, by either clarifying the scope of Article 21 of the original model law explicitly to say that it provides, that it includes the issue of enforcement of judgments, and or also enacting the other provisions of the model on judgments to clarify also the process for recognition and the grounds for refused enforcement. Thank you.
So just really quick. So I don't disagree with any of that. Maybe I've been a judge too long, and what I'm really good at is distinguishing case law I don't like. So that's my approach. But I just want to, before I turn it over again, I really recommend the expert in the United States isn't me on Chapter 15. It's Martin Glenn out of the Southern District of New York, who's currently the chief judge there, and a terrific, real intellectual and scholarly judge. He has a very good article that I would recommend. It's available on the UNSA trial site, and it's called Model Law on Cross-Border Insolvency, the Judicial Perspective. And he has a very extensive discussion of Rubin and some of the related issues in that article. So I highly recommend that to anyone who wants perhaps a more nuanced view than I gave, certainly a more nuanced view than I gave, and is more probably in line with what here it said.
And it's a 2012 judgment, and we're still talking about it. So
yeah,
I'm sure there would be other judgments on the other side, and the less discussed though. So yeah, and so
well, the very first opinion I wrote on Chapter 15, I refused to recognize in effect a judgment, a ruling in a bankruptcy in Japan. I didn't know anything about universalism or territorialism. So as I became more educated, it's one of the very many cases I've written in my past that I somewhat regret, but it's important to be educated on these issues. And I came on the bench in 2006, as did the model law in the US. So I've been learning in the most difficult situation, which is learning by making decisions, interpreting a law that I wasn't familiar with before I became a judge. But we do the best we can in this job.
Sure, and thanks, Judge. And this is actually a proof of the pudding question, and it's to Eric Danner. So to embark on a practical economic discussion of cross-border insolvencies or bankruptcies. Now, do you think the protocols, model DOS, et cetera, have really caused cross-border bankruptcies to succeed? That's part one of the question. Do you think, you think these protocols and laws are working really? The second is in terms of very specific issues on retail companies' insolvencies. How do you deal with retail companies' insolvencies? And the third is, what other industries do you think will get exposed to cross-border insolvencies in the near term?
Thank you. I appreciate the opportunity to speak with everyone today. And so in order to allow for some time for questions at the end, I will cut down a little bit of my presentation here, since my fellow panelists have spoken so eloquently on various technical aspects of the cross-border insolvency matters. I'll take the opportunity to take the discussion in a slightly different direction. My charge was to bring a somewhat different perspective to today's conversation, so I'll try to do that. As a financial and operations advisor, my job is to shepherd client companies through successful reorganization schemes and processes, really working shoulder to shoulder with company management in a real-time environment that includes not only high-level strategic considerations and planning, but also ground-level tactical execution of various initiatives as you move through the game plan. And an area where I've been paying increasing attention lately is almost the psychology of companies that are in insolvency, which gets to your question about whether or not this is working, because professionals in the space can make things work, but I find it interesting to look at it from the perspective of those business people who are actually living through the process as to whether or not it, in a very pragmatic sense, is actually working. And like many of my fellow restructuring professionals, I often reflect that my formal training probably should have been in psychology as opposed to business, since so much of what I do is working with company teams to help them through what in all likelihood is the most difficult moment of their business careers. And I suspect that that's a view shared by many of my fellow Indian insolvency professionals as well. And I find these psychological factors to be most interesting when the core matter is operating business that is looking to move through a cross-border insolvency process as effectively and rapidly as possible. And so it's important to remember that in what is sometimes an uber clinical exercise of conducting an insolvency proceeding, there is still a company and business people in there somewhere. So there is a human element to it all that I think, as I said before, provides the ultimate litmus test as to whether or not something is actually working. And so we're all, as insolvency practitioners, accustomed to cross-border insolvency rules and regulations. The model law construct sometimes works well, sometimes not, but we accept it as part of our reality. We have a familiarity with it that client companies and business people simply don't have. They've got no comfort level with literally anything that's going on, as most managerial teams have never been through a restructuring exercise. It's typically their first go around and they feel like fish out of water. So simply understanding the insolvency framework of the home country where the primary proceeding is based is challenging enough for these people to make sense of all of that. But then when you overlay the insolvency framework of other jurisdictions that have parallel proceedings unfolding as you move through the overall insolvency, you end up with a very complex mosaic that can be completely bewildering for these people. And I had a reality check not long ago with a Chapter 11 process that involved complementary proceedings in Canada, Chile, Brazil, and Italy. And all of those geographies had business entities with physical facilities and employees. And so there was a real critical mass to each of them, but the primary proceeding was in the United States. And so the US team was very driven to try to move through the insolvency process as rapidly as possible and ideally harmonized with the other jurisdictions on key areas like treatment of workers, wages and benefits, contractual agreement enforcement, that sort of thing. But there was a great deal of frustration on the part of the US parent company that it had on many, many occasions to wait on the overseas jurisdictions to review and improve decisions and court rulings that had already been issued in the United States. Now, the reality is those jurisdictions were entirely appropriate in exercising due care to ensure their creditors were protected. So I'm not criticizing, but it certainly did add delay to a process where people recognize the value of trying to step through it as quickly as possible. And I kept telling the management team of the US company that, but for model law framework to be followed here, this would be supremely dysfunctional. And they viewed that with a high degree of skepticism that this was in fact an efficient and effective process because they hadn't seen what had existed before. But I do think it underlines the reality that we need to continue to evolve the efficiency and eliminate some of the ambiguity that does continue to exist with some of these cross-border restructurings despite everyone's best efforts. So there's a continuous improvement element to all that I think speaks to whether or not it's working. You asked a specific question about a couple of industries. Clearly rising interest rates across the globe are going to put pressure across all sectors. So there is sort of a broad-based reality that restructuring professionals here are going to get busy, just as the US Federal Reserve increased its Fed's funds rate, I think by 75 basis points earlier this week. I know the Reserve Bank of India has done the same thing, I think 50 basis points. And so everyone's moving aggressively. And for floating rate debt, that's going to have pretty dire implications for people struggling already to service their debt. You asked about the retail sector. I'm smiling because the flippant answer is that the retail sector always appears to be in some degree of distress. I liken retailers to farmers, that it's either raining too much or too little. It's never just right. But in truth, retail appears to be relatively healthy right now. There were big bankruptcies in 2020. 2021 saw rationalization, not so much in the form of massive bankruptcies, but just store closures as people got a bit more sensible about what their physical footprints were going to be in terms of retail space. And actually, since the back end of 2021 into now 2022, we've seen a lot of expansion where there have been new store openings, especially in the space of discount retailers like the Dollar Generals and the Dollar Trees of the world, where people in a very value conscious economy, especially given rising inflation rates, is going to continue, I think, to be strong. So I don't see any significant additional distress in the retail sector. I will give you one sector, though, to watch, in my view, that my company is certainly spending a lot of time taking a long, hard look at, and that is the logistics companies, especially those that provide ocean cargo and land-based cargo transportation services. That industry right now is doing very well, given the fact that it can command pretty much any price it wants. However, it's in the hubris of that type of favorable pricing environment that people expand, get out over their skis. And so as margins contract in the future, I think there's real opportunity to keep an eye on that as companies necessarily need to contract, and there's some winners and losers. And marine transportation companies are especially interesting to me because not only do they have enterprises that dot the globe and are domiciled in many different countries, they literally have physical assets that on any given day are far flung across the world. Their ships, their cargo containers that will be in many jurisdictions if the company were ever to file insolvency. So I'll stop there and hand it back to the moderator. Thank you.
Yeah. Thanks, Eric. And this is going to be this next set of questions, but let's keep it very short. I mean, a minute or a minute and a half, and then we'll take a few questions from the audience. The first is for Mr. Deora. In reference to the recent and evolving jurisprudence and judgments around recognition and enforcement of insolvency, cross-border matters, etc., what would your view be on India's Part Z? Should we recalibrate Part Z? What would be your top 2 recommendations on changes to Part Z, if you think it's necessary?
Well, you see, the objectives and the scope is completely aligned with the ancestral model law. And of course, over a period of time, we would get to realize what all changes we make. As a first step, we must take to attract business into the country and make business more facilitative. And without going into the preamble and the objectives, well, one good thing is that there's a carve out for, this is Section 1, subsection 5, which talks about clause 29, and which talks about how the foreign assets of Indian corporates can be dealt with, for which special bilateral agreements can come by. So if an Indian company's got debts to recover overseas, which is what I often see, there's no way you can get that money, as Mr. Mittal also mentioned. So probably this 1, subsection 5, with the help of 29, can provide those kind of bilateral arrangements where monies can be recovered from overseas. Companies' insolvencies do not get funded fully, or monies don't come back home. Of course, you have the provision in 234, 235, but that's not been acted on until now. The other thing is everybody's alluded to is the public policy, and what Ashish also mentioned is about this reference to central government. There's enough jurisprudence on public policy in India and amongst the civil legislations interpreted by the courts in the past. There's enough guidance available, but surely not in the laws of insolvency. So the government intervention is something here which probably is going to be business accretive, because government is seeing everything in a very positive light. The third important aspect, which some people have not touched on, is regulation of the foreign representative. So a foreign representative will have to register himself with the Insolvency and Bankruptcy Board of India. Be subject to that disciplinary proceedings and other actions, and there are very high penalties provided for any wrongful actions. So, well, this comes from the perspective that there have been instances of securities markets in the past where some foreign consultants, advisors, foreign registered entities, or merchant bankers or lead bankers from overseas came and issued securities for the Indian market companies, and they were not regulated by the Securities Board. I just have a minute I'd like to deal with three quick examples in Gujarat, which had less liabilities in the US. And Judge Peck gave the judgment. Judge Peck was
Rajivji, could you go off your video? I mean, we have a bit of a lull.
Based proceeding.
Is Sajivji clear? No. So could you go off your video? It would improve your audio, I guess. Sure. And if I were to, he can come back when it gets better. If I were to ask the same question to Mr. Makhija, Mr. Makhija, what would your answer be? The top two things that you'd like to, propose as changes.
Okay, Shripriya, the fact that, you see, this is a new law, I think adopting ancestral model law is always a good thing, because we have to learn from the experience of the other jurisdictions. I think a lot of debate has happened on Rubin judgment. It also had our view, and even Judge Chris also gave his views. I am of the opinion, look, insofar as any law is concerned, there is always a purposive ambiguity which is left out. And that has to be interpreted by the courts. And that is learning over a period of time and by experience. I'm only worried from a legal perspective. I'm not worried on the factual issues of the center of main interest or establishment, because these are more dependent on the factual position. I'm worried about, more concerned about the issues of forum shopping, which is very, very important and which has been given a new name nowadays, international insolvency tourism. People, the companies are shifting the registered office just at the verge of being underwater. So therefore, those are the questions which have to be really dealt in a legal manner. Then I'm also concerned about the participation of the foreign creditors. There is a Polish judgment where Government of India filed a claim for the tax authorities filed a claim. The foreign tax claims were not permitted. And that's the case of the Polish law under the Polish Bankruptcy Act. Government of India versus Taylor. Well, so these are certain aspects which really need to be seen over a period of time. And the other aspect, I think, in Rubin judgment, which has been discussed, is relating to the avoidance transactions. Now, whether it is to be the home country rule, whether it is to be a basis of a significant contracts, because in a Maxwell case, significant contracts concept has been put in, rather than in India, even we go for avoidance transactions for even 100,000 rupees or maybe 200,000. Whether it is significant contracts or not, I think that is some issue which will be developed over a period of time. So I would like to see some changes, but not at this stage. If you ask me, I would say, please adopt the model law with minor tweaks as we have done or as US has done. That is good enough. Let it develop over a period of time, because these concepts, Indian judiciary, I would say we are mature enough to decide all these issues over a period of time. So over to you, Shripriya.
Thanks, Ashish. And this is to Mr. Mishra, and we sort of move to the next question a bit quickly, and my apologies. I completely concur with you when you say that the Indian framework has to just get more robust, sir. Whether it's in terms of the stakeholders' understanding of the process, whether we're talking about lender liabilities, whether we're talking about capacity of RPs, whether we're talking about NCLTs doing adjudication faster, much, much faster than the present rate, yes. But specifically on the issue of cross-border insolvency, what would be your, key asks as somebody from the industry, as somebody who's a potential buyer? What would you want from an RA perspective, and any of your general thoughts as well? 2 minutes, please.
Thank you, Shripriya. The first thing is equality. I'll ask for three things. The first thing is equality in terms of A, is that protection and safeguarding of the interest of domestic and international creditor at par. Both has to be at the same level. B, the protection and preservation of the value of the asset of the debtor lying in more than one country. That's number one. Second is coordination and cooperation between the laws and judicial practices of different jurisdictions. This coordination has to happen from this. Then the third thing is standardization and harmonization of insolvency practices of different jurisdictions. Because actually the nuances are there in the rules, and how you go through the processes with the time-bound manner and all with hassle-free things to the industry, where they are acquiring certain assets, and if they have to go through this daily pain or for years and all, so that need to be seen in the context of the Indian scenario, and all those learnings need to be implemented here proactively so that we do not go through the same pain again and again. Thank you.
Thank you, Mr. Ji. Yeah. And the next is for Professor Erit. The genesis of cross-border proceedings depends a lot on the COMI, which is the center of main interest. A very quick summary on how do you think it's been interpreted in different jurisdictions? How can I make COMI as a concept more robust to prevent forum shopping?
So, thank you, Supriya. So yes, COMI is quite central to the model law regime, also to the EU regulation. It has followed the EU insolvency regulation. This concept of COMI, center of main interest, functions a little bit differently in the context of the model law, but equally important in the sense that it is the basis for recognition of foreign proceedings as the main proceedings. And that also results in some automatic relief in the form of the stay of the moratorium, and then additional potential discretionary relief that will aim at centralizing the process as much as possible in that main forum, in accordance with the concept of a modified universalism that we discussed earlier. And COMI, center of main interest, was chosen in the context of the EU and globally because it reflects a real connection between the debtor and the main forum. It is the center of main interest of the debtor. But still, the concept is and is supposed to be flexible, at least to some extent. But because it is flexible, it also resulted with some inconsistencies and controversies in terms of its implementation, which globally eventually led UNCITRAL to deliberate more and eventually to revise the guide to enactment to the model law in 2013. And that is an important instrument to highlight here. The guide to enactment to the model law is really important, both for the drafting stage, but also later in the application stage. So with regard to COMI, that a revised guide to enactment to the model law explains that the main factors for determining COMI are the place of the central administration. This is the main factor, the place of central administration, namely the real head office of the company, as ascertainable by third parties. So not just a hidden head office, but a real head office that is known to third parties. And also to your question about how to prevent forum shopping, the guide, the same guide to enactment, the revision of it in 2013 also looked into that issue of forum shopping and eventually recognized that COMI may move, that it is possible to move the COMI, and it is sometimes okay to move the COMI. It's not necessarily a bad thing. It could be for good reasons, where creditors are generally on board, and the idea is to be located in a country that where I can restructure the business in a way that is beneficial for the stakeholders, and I can't do it in the original form. So I may even shift my COMI at times approaching insolvency. And so the guide recognizes that, and it doesn't prohibit this COMI movement, but it does direct the courts, the receiving courts, courts in countries that adopted the model law to scrutinize more carefully the conditions of COMI, the factors of COMI, in such circumstances where the move took place in close proximity to the opening of proceedings. You're muted.
Yeah, so thanks, Irit. And I think going forward in these webinars, maybe we'll just take up COMI as an idea and look at how it has to evolve and how the Indian courts would have to, look at COMI. And of course, we have some parallels with our tax laws, center of economic interest, etc. So I'm sure there'll be some valuable learnings that our forums would pick up. The next question is for Judge Sonshi. India has a Part Z model draft law and is sort of heading towards getting it out. If I were to ask you, what are your top 2 recommendations for a jurisdiction that's going to go into cross-border for the first time? Top 2. What should we be careful about, Judge Sonshi?
One, don't, as a judge and as a practitioner, don't feel like you're a servant or a slave to the foreign jurisdiction. You have your autonomy. You need to balance the purpose of a worldwide reorganization and respecting the foreign proceeding with appropriately asserting your personal jurisdiction, your judicial power over your domestic assets and creditors. You are not surrendering. You are cooperating. I think that's very important. Second, it's a learning process. Judges are going to make mistakes. The lawyers are going to make mistakes. It's going to take the lawyers a while to get up to speed. It's going to take the judges a little while to get up to speed as is the case anytime there's a new change in the law. So I would be patient with the court. I would have the court be patient with the people appearing in front of the court, and everyone understand that it's a learning experience, and the law will develop, as Ashish said, as it always does. The law will develop over time. Those are my two primary points.
Sure. And the last question and the conclusion. So we're talking of very linear laws where countries will come up with laws that would have a start and a defined end. But in the context of international insolvency and cross-border, I think there's need for a lot more fluidity. How do you ensure seamless integration of laws? So if I were to just wrap up this webinar with this question, in terms of just a statement or 2 from each of you on how you think, and it doesn't have to be the structured, jacketed framework that the model law provides for. In your own view, how do you think we can make this, truly a world without borders? How do you make the cross-border insolvencies work? Mindset changes. So let's start with Irit.
So I would say on the first stage, adopt the model laws and adopt them with minimal modifications just to adjust them to your system. And then train the professionals and the judges and interact with other judges in other jurisdictions so that you can trust other systems more and you can trust the international insolvency more. So we need to develop trust. I think a trusted instrument and a trusted regime will work properly. So I would say developing trust through interactions, through involvement in various forms after drafting, that would improve the application and the system generally.
Sure. And I'll take a few questions maybe. I mean, unless somebody else wants to say something. I mean, Judge Sonshi, how do you think we can make this more fluid?
I think it's important that judges be willing to learn, to embrace new ideas, to be flexible, and to be respectful of foreign jurisdictions and their different approaches to trying to solve the same legal issues that we have to solve in our own countries.
Sure. Ashish ji?
Okay, I would also say the same thing, that respecting the other jurisdictions. See, at the end of the day, a judge interprets in a particular way, because interpretation is what matters in the law. Now, that interpretation, and we always say in the rules of interpretation that the text and the context must match, and the content and the intent must match. So if that is matching, I don't think the other jurisdictions can question that. So the idea is to respect, and of course, the other point which has been brought out by IRATE also, training the judges. I think that's extremely important, because this is something where a new law is coming. The training is extremely important for judicial officers.
Raghupati ji, and thank you Ashish ji. Raghupati ji.
Yeah, I think all the panelists has given the right suggestions. What I could add is that if you see if you see the whole gamut of the issue, some 80% of this everybody will agree. So let's agree on something first. The majority of the things, when you have region and logic, everybody will agree on that 80%. The balance 20% will sort out later over the months. That should be the approach.
And Eric, you have anything specific to add here?
Yeah, I echo the thought that there's no substitute for training, for experience, most of which will be learned through actual insolvency proceedings. But just want to remind the group, and I guess this is my perspective as a practitioner, is that it's not just a clinical exercise. There will actually be companies that are trying to move through this process. And so I understand that some of them may be a test balloon, but there are actual companies that will need to be the guinea pigs for this. And so I think folks just need to be mindful that that oftentimes there's a bit of a melting ice cube aspect to some of these companies, that you need to act with some degree of rapidity in order to preserve whatever value might exist at the onset of an insolvency proceeding. And it certainly makes sense to use those as live fire exercises to get people accustomed and educated to everything, but hopefully not at the expense of the survival of the company at the middle.
Sure. Thanks, Eric. And I'm going to have one audience question. Most of these questions have actually been answered, but nevertheless, and I'm going to end with the opening batsman today. So, and that's the question to Mr. Sajeev Ziora. Must also mention that we've had very, very good comments and appreciation in the chat, and a lot of people have written in to say that this was a very, very valuable session and very good insights. So to Sajeev ji, there's one question. Our audience today comprises predominantly of insolvency professionals. So everybody would like to understand what it means for them. How would this expand local markets? How do you, what's in it for me, and what should I do about this?
Well, this is an issue we've been discussing at IIPI for long enough as to how to make everything more international. So if foreign representatives will come and be in India, can we also do the same likewise? And I'm sure IIPI is very conscious of this fact. Institute of Chartered Accountants has got mutual recognition agreements with institutes in other countries. Of course, it's a WTO Mode 4 issue, and I'm sure Institute of Chartered Accountants is live to it. And similar recognition agreements for insolvency professionals may come by over a period of time. Let's recognize the fact that the IBBI has recently come out with guidelines about insolvency professional entities and larger businesses wanting to do turnaround services. So that's a real open approach to coming years of practice. So maybe alliances with foreign parties, with foreign firms, with law firms for lawyers, with accounting firms for accountants should be permitted in the insolvency field, so that there's greater learning that takes place and there's more cooperation and more similar like webinars and seminars take place, and we all get the benefit of collective learning.
Thank you very much. And thank you, Sajeev ji, for this very wonderful deliberation. Ashish ji, for your time. Raghupati ji, again, for your time and your insights. Eric, and I'm going to suffix it with a G. It's J-I. That's what we do in India. It's the suffix of respect to Eric ji and to Christopher ji. So thank you very, very much for having been here this evening. And We look forward to the next session in future. And my thanks are also in order to Mr. Rahul Madan and his team, who put in an exemplary effort whenever we do a session like this. We'd also like to thank Prerna ji, and over to Rahul ji for any other credits, and then we can close.
Thank you, Sri Priya ji, for your effective coordination, and all over. I am getting these messages from here that your coordination is the best. Thank you.
I agree, and thank you, Shri Priya ji. And we have Dr. Haldia with us towards the end. Sir, would you like to say a few words while we close the session? Dr. Haldia, if you could hear us.
No, thank you, Rahul. I have been all through these sessions and extremely enlightened and delighted to hear the views of the participation and the moderation by Shri Priya ji, the industry insight by Mr. Mishra, and also by the legal and the regulatory perspective from the others. Just two things. One is that the chairman IBBI was looking towards, he posed certain questions, and we had among the issues, those was cropped up in the deliberations, those were also addressed. So maybe we frame a response to those, and also the other recommendations and the issues and challenges that they have emerged, and send it across to IBBI. And the one thing that Mr. Devara posed was the mutual recognition, cooperation and coordination between the different players in the cross-border insolvencies, and the insolvency professional is one among those. That is receiving our attention to the audience, I would say. And we had briefly spoken to the IBBI, and they are also quite conscious of it. As the cross-border insolvency framework is in place, I would believe that would be the next steps to take forward. In any case, as a preparatory exercise, we are in dialogue with the different institutions, the regulatory bodies in other countries, and the insolvency professional bodies in other countries, establishing rapport and the contacts, so that as the time arrives, we are in a position to capitalize on that. One important thing is that it's not only the coordination and cooperation or recognition of the insolvency professional that is important, but we have to bring together all the participants in the insolvency, in the cross-border insolvency. Would that be the bankers? Would that be regulators? Would that be judicial authorities? And in fact, as a triple IPI, we are just trying to create a platform for mutual exchange of ideas, thoughts, and identify issues and challenges, is ensuring that coordination and cooperations. We have spoken to the NCLT. We would be organizing some forum, again, an international forum of those concerned with the judicial processes. And the cross-border insolvency would be one among those. We were also thinking in terms of a forum for the bankers as to what kind of problems the Indian bankers face, what is the response from the other sides, and what problems the bankers from other countries face when they are involved to cross-border insolvencies in India. So that's an ongoing process, and I believe, as I said in the beginning, the cross-border investment, trade and industries has become very common, a routine phenomenon, and therefore, if we need to address corporate insolvencies in an effective way, cross-border insolvency has to be, and the time has come sooner than later. Thank you very much, and indeed, I only say my gratitude and thanks to all the panelists for such an excellent deliberations. Thank you, Rahul.
Well said, sir. Thank you. And thank you, Shri Priya ji, again, all the distinguished panelists. I look forward for more such capacity building initiatives, and thank you III team in USA, especially Sherry, to coordinate this particular platform. Look forward, and all the best. Have a great weekend and great day. Thank you.
Thank you very much.
Bye.
Thank you.
Thanks especially to Sherry. Thanks. Thank you so much.